Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. Today in this video, I am going to discuss one more important question relating to the company law. That is generally asked for 20 marks in the previous. That has been asked for 20 marks in the previous year exams, and that is one of the most important question for the upcoming exams also. My question is: describe the circumstances when the corporate will of the company can be lifted and the separate legal entity of the company can be disregarded. Describe the circumstances when the separate legal entity of the company can be ignored. So this may be asked in any of the form. If we talk about the circumstances under which the corporate will can be lifted, it can be classified under the two heads. First, under the judicial interpretations, and second one is under the statutory provisions. जैसा कि मैंने आपको बताया कि जब हम बात करते हैं कि कॉर्पोरेट विल मतलब कंपनी की जो अलग पहचान है उसको इग्नोर किया जा सकता है, और कुछ ऐसी सर्कमस्टांसेस बताई जा रही है जहाँ पे कंपनी की अलग पहचान को इग्नोर किया जा सकता है और ये देखा जा सकता है कि वास्तव में वो कंपनी के अंदर कार्य करने वाले मेंबर कौन हैं, हु आर द रियल मेंबर्स, हु आर द रियल बेनिफिशियरीज ऑफ द कंपनी। और इसको दो भागों में डिवाइड किया जाएगा। फर्स्ट इज जुडिशियल इंटरप्रिटेशंस, न्यायिक निर्णय के आधार पे, और सेकंड वन इज स्टैट्यूटरी प्रोविजंस। यदि हम जुडिशियल इंटरप्रिटेशन की बात करते हैं तो सबसे पहला जो पॉइंट रहेगा दैट इज डिटर्मिनेशन ऑफ द एनिमिक कैरेक्टर ऑफ द कंपनी। अंडर द जुडिशियल इंटरप्रिटेशन, फर्स्ट पॉइंट इज डिटर्मिनेशन ऑफ द एनिमिक कैरेक्टर ऑफ द कंपनी। Occasionally it becomes necessary to determine the anemic character of the company or to determine whether the property of the company is the enemy property or not. In such a case, court may examine the character of the persons in real control of the corporate affairs. It was held in the case of Daimler Company Limited versus Continental Tire and Rubber Company Limited, that is Great Britain, in 1916. In Great Britain in 1916. In this case, the company was incorporated in London for the purpose of selling tires manufactured in Germany by the German company. The majority of the shareholders of the company and its directors were Germans. Thus, the real control of the company was in the German hands. During the First World War in 1914, the company filed a suit in the English court to recover the trade debt, but it was pleaded before the court that the company belonged to the alien enemies and therefore it should be restrained from recovering the trade debt. The House of Lords held that the company through incorporated association was an enemy company and its real character was German. Its director and shareholders except one, and its actual beneficiaries were the Germans. So the company was not allowed to proceed with the action to recover the trade debt. Thus, the company may assume enemy character when the person in de facto control of the affairs are the resident in the enemy country, and they are the resident. They are acting under the control of enemies, or the residents are acting under the control of enemies. But where the company is such, where there is no danger to the public interest, the court may refuse to tear upon the corporate will. As it was held in the American case, that is People's Pleasure Park, and that was held in the American case, that is People's Pleasure Park Company versus Rohelder. Thus, we can say that in order to recognize the enemy character of the company's corporate will can be lifted. This is the first circumstance. Second circumstance, when that is for tax evasion or for benefit of revenue. If a company is used for the evasion of tax to circumvent the tax obligations, the court has power to disregard the corporate will of the company. On this point, there is illustrative case, that is case of Sardinsa Maneksa Patil in 1927 of the Bombay High Court. In this case, the assessee was a wealthy man who was enjoying a huge dividend and the interest of income. He formed four companies and transferred his income in the part to each of these companies in exchange of their shares. Now the company received the dividend and interest income, but they were handed back to the assessee as printed in the loan. So he divided the income into four parts. So he divided his income into four parts in order to reduce the tax liability. The court disregarded the will of the incorporation and found that the company was formed as a mean of avoiding the tax, as a mean to avoid the super tax. In the another case, that is Income Tax Commissioner Madras versus Sri Meenakshi Mills Madras in 1967 by the Honorable Supreme Court. In this case, Honorable Supreme Court has observed that the income tax authorities are entitled to pierce the corporate veil. Means veil of the corporation can be lifted by the income tax authority also, and look at the reality of the transactions. And another case, that is Bachcha F. Gujdar versus Commissioner of Income Tax in 1955. In this case, the Honorable Apex Court has held that though the income in the hands of the company was partially agricultural, yet the same income when received by the shareholders as dividend could not be regarded as the agricultural income. This was the second condition when the corporate veil can be lifted. Means where the company has been formed in order to evade the tax liability, the corporate veil of the company can be lifted. And the third condition when the corporate veil of the company can be lifted, that is the prevention of fraud and improper conduct. Where the company has been formed in order to defraud a creditor, in order to defraud or for the improper conduct, then also the corporate veil of the company can be lifted. Means legal personality of the company may also be disregarded in the interest of justice when it has been used for some illegal or fraudulent purpose. The court will refuse to uphold the separate existence of the company where it is formed in order to defeat or circumvent the law, to defraud the creditors, or to avoid the legal obligations. It was held in the case of Guilford Motor Company versus Horney in 1933. In this case, the Mr. Horney was appointed as the managing director of the plaintiff's company on the condition that he shall not at any time while holding the office as a managing director or afterwards solicit the customers of the company. He was terminated under the agreement. Thereafter, he formed a company which solicited the plaintiff's customer. It was held that the company was mere a sham and clock, and the defendant company was mere a channel used by the defendant Horney for the purpose of enabling for his own benefit to obtain the advantage of the customers of the plaintiff's company. So the defender's company ought to be refrained, as well as defendant Horney in the another case of Jones versus Lipman. Lipman agreed to sell. In the another case of Jones versus Lipman in 1962, Lipman agreed to sell a certain land to the Jones. He subsequently changed his mind, and to avoid the specific performance of the contract, he sold it to a company which was specially formed for the purpose. The company had a Lipman and a clerk of his solicitor as the member of the company. James brought an action for the specific performance of the contract against the Lipman. The court looked behind the reality of the situation and cancelled the transaction and cancelled the transfer deed in the favor of the company and ordered the specific performance of the company. Ordered the specific performance against the Lipman. And then where the company has been formed in order to defraud the creditors, then also the corporate will of the company can be lifted. Thus we can say that corporate will of the company can be lifted, or the company separate legal entity of the company separate legal entity can be ignored where the company has been formed in order to defraud the creditors also. It was held in the case of official liquidator versus Bagri Brothers Limited. Official liquidator versus Bagri Brothers Limited. In this case, the trader was liable to pay the debts of his creditors. In order to save himself from the repayment of debt, he converted his sole proprietorship business into a company, and he appointed himself and his wife as the director of the company, and subsequently he declared himself as insolvent in order to avoid the payment of the debts. This was the case where the company's separate legal entity was ignored, as the company was framed in order to defraud the creditors. And another condition where the company's separate legal entity of the company can be ignored, that is where the company is incorporated to act as an agent of the members. Where a company is acting as an agent of its shareholders or of another company, it will be liable for its acts. A government company is not an agent of the state unless it is performing the sovereign functions. And another point where the company's separate legal entity can be ignored, that is avoidance of the contractual obligations. If a company is formed only to avoid the obligations arising out of contract, the court may lift the corporate will, as it was held in the case of Jones versus Lipman. And the next condition where the corporate will of the company can be lifted, that is in the interest of company. Sometimes a company itself wants that its separate legal entity should be avoided and must be treated alike with the members. And the next condition where the corporate will of the company can be lifted, that is the avoidance of welfare legislation. If the sole purpose of the formation of the company was to use it to advise as to reduce the amount of payment by way of bonus to the workers or to avoid the taxing laws or welfare legislations, means where the company has been formed in order to avoid the welfare legislation, the Supreme Court can lift the corporate will of that company. Means separate legal entity of the company can be ignored where the company has been formed in order to avoid the welfare legislation. And another condition where the corporate will can be lifted, that is to ascertain the true nature of the transactions. Court would be justified in piercing the corporate will of the company to ascertain the true nature of the transactions and whether the transactions are genuine or not, whether the transactions are bona fide or not, in order to recognize the true nature of the transaction. The corporate will of the company can be lifted. And another condition of the corporate will, another condition where the corporate will can be lifted, that is in the case of economic affairs, economic offences. In the case of economic offences, court can lift the corporate will also and pay regard to the economic realities behind the legal facade. This was all about the conditions where the corporate will can be lifted under the judicial interpretation. And another condition where the corporate will can be lifted, there are certain statutory provisions also. Means under the statutory provisions. First condition where the corporate will can be lifted, that is reduction of the membership below the minimum limit as prescribed by the Companies Act. Under the Companies Act, when the company carries on business for more than 6 months, after its number of members it reduces, in the case of public company below 7 and in the case of private company below 2, every member who is aware of this fact shall be jointly and severally liable for the payment of whole of the debts of the company contracted during that time. Means where the memberships regarding the provisions relating to the Companies Act has not been fulfilled, the company corporate will can be lifted and company would be liable for all the debts all the payments that has been contracted during that lifetime, during that time. And the another statutory provision where the corporate will can be lifted, that is misdescription of the name of the company. Under section 12 of the Companies Act, where the name of the company is not properly used in the contract or negotiable instruments, in the contract or the negotiable instruments, and there is no indication that acts are done on the behalf of the company and every officer will be responsible, and the directors will be personally liable also. Hendon versus Alderman and others in 1973. In this case, the name of the company was stated as LR Agencies Limited, whereas the company's actual name was L&R Agencies Limited. The signatory directors were held liable for the misrepresentation of the name of the company. And the another condition where the company's corporate will can be lifted under the statutory provisions, that is misrepresentation in the prospectus. Under section 34, it provides that where a prospectus includes any statement which is untrue, every director, promoter, or every person who authorizes the issue of such prospectus, every directors, promoter, or every person who authorizes the issues of such prospectus shall be liable under section 447 of the Companies Act. Also under section 35, where a person has subscribed for securities of a company on the basis of misleading prospectus and has sustained loss or damage as a consequence, the company's director, promoter, and every person who authorizes the issue of such prospectus shall be liable. But a person is not liable if he proves that such statement or omission was immaterial. And the another condition where the corporate will can be lifted under the statutory provisions, that is failure to return the application money. Under section 39, it is provided that company's prospectus and allotment of rules 20 clause 4 prohibits the allotment of securities where the minimum subscription has not been subscribed within 30 days from the date of issue of prospectus. In such a case, amount is to be refunded within 15 days from the issue of prospectus, from the closure of the issue. In the case of default, company and its officers who are in default shall be jointly and severally liable to repay that money with interest at the rate of 15% per annum. And the another condition where the company's corporate will can be lifted under the statutory provisions, that is holding and subsidiary company. Under section 29 of the Companies Act, a holding company is required to disclose to its member companies of the balance sheets, income statement, and audit reports of each subsidiary company be attached to the balance sheet of holding company. And the next condition, that is investigate the affairs related to the companies. Under section 219, it provides that if an inspector appointed under section 210 or 212 or 213 to investigate the affairs of the company, he shall also have power to lift the corporate will of the company in order to investigate the affairs related companies in the same management. And the next condition, that is to investigate the ownership of the company. Under section 216 of the Companies Act, it is provided that the central government can appoint one or more inspectors to investigate and report on the membership of the company to determine the real ownership of the company. And the next condition under the statutory provisions, that is liability for ultra-virus acts. All the contracts which are beyond the power and are not authorized acts are ultra-virus acts. And the directors and other officers of the company will be held personally liable for all the ultra-virus acts that is done by the company. It was held in the case of weeks versus part. In this case, a railway company had exhausted its borrowing power. However, the directors of the company advertised for taking the loans on the security of the debentures. Directors were held liable as they had warranted in the advertisement that the company had the power to borrow. And the another condition where the corporate will can be lifted, that is liability for pre-incorporation acts, pre-incorporation contracts. A pre-incorporation contract means a contract that is entered into by the promoters before the formation of the company. In such contracts which are not adopted by the company, the promoter shall be personally liable for all such contracts which are pre-incorporated. And the another point under the condition where the corporate will can be lifted, that is the fraudulent conducts. Under section 339, if in the course of winding up of the company it appears that the business of the company has been carried on with intent to defraud the creditors, any person who is or has been director, manager or officer in the company shall be personally liable for all the acts or any of the debt or other liabilities as the tribunal may direct. And the last condition for the ignoring the separate legal entity of the company, that is liability under the other statutes. Directors and other officers may be held personally liable under the statutes. For example, under the other statutes also. For example, under the Income Tax Act, Foreign Exchange Management Act, that permits the will of the company to be lifted in certain cases also. This means under the other statutory provisions, company's corporate will can be lifted and liability can be imposed upon the officers of the companies also. There are also certain conditions where the company's corporate will can be refused to lift. Means refusal of the lift of the corporate will can be done also. The purpose of the lifting of the corporate will is to prevent the misuse of the corporate entity by the companies. In following cases, the court can refuse to lift the corporate will also. First is in the national interest. Where the lifting of the corporate will go against some national policy, the court will not do so. It will refuse to lift the corporate will. It was held in the case of LIC versus Escort Limited in 1996. A group of 13 companies incorporated abroad and applied for the permission under the Foreign Exchange Regulation Act for the purpose of shares of the Indian company. It was argued that the 13 companies belonging to single person and was operated by single person. So the Foreign Exchange Regulation Act was violated. Honorable Apex Court did not accept this argument and refused to lift the corporate will as it was in the national interest. And the another condition where the corporate will was ignored, corporate will was refused to lift the corporate will. Court has refused to lift the corporate will. That is the protection of revenue. Sometimes separate entity of the company may be maintained for the purpose of avoiding the tax liability also. And the next condition, that is government companies. Majority of the shares of the government companies are held by the central government and the state government, or both of them. In such cases, in such companies where all the shares are held by the government, the court generally refused to lift the corporate will, as it was held in the case of Bharat Aluminium Company versus Special Area Development Authority in 1981. This was all about the conditions where the corporate will of the company can be lifted, and also the conditions where the corporate will could not be lifted. Court has refused to lift the corporate will. And this is also one of the most important questions for the examination point of view. That has been asked in the previous year exams for many times. And it is also important for the upcoming exams also. And if you have any doubt, then you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.